Sorry that I could not be with you live today, and I'm sending you this pre-recorded speech. Actually, my flight got delayed, and by the time you're going to be listening to this, I must be in the air somewhere. So very sorry on that account. So good morning. It's a matter of great honor and privilege to be able to share some of my thoughts on how the judges or the judiciary look at climate change, climate justice, and the scope and future of climate litigation. At the very outset, it is underlined that the primary responsibility to address and devise ways to deal with climate change rests with the government of the day. In a democracy, it is the political party in power to lay down the policy and for the parliament to introduce laws to deal with climate change. We, the judges or the judiciary, get to play our role when a case comes up before us. No matter how proactive our approach, our jurisdiction has to be invoked by a concerned citizen or a robust civil society. Judges are not elected by the people and thus have no political constituencies or political interests to watch for. Their oath is to uphold the Constitution, which means to uphold the fundamental or the human rights of the people. Neutrality and impartiality by design leaves the judiciary as the only institution that can effectively advance the cause of human rights, irrespective of the fact that it is against the vested interests, government policy, or even upsets the political balance of power of the day. Using the creative tools of interpretation, the ever-evolving international environmental principles, and a focus on progressive advancement of human rights, the courts have made a difference and made innovative strides in developing climate jurisprudence that promises hope. Initially, our courts evolved a rich jurisprudence on environmental justice, which revolved around penalizing the polluter and curbing pollution, largely a localized issue with an ascertainable polluter. The equation totally changed, however, as we moved on to climate justice. For a country like Pakistan that suffers at the hands of climate change and contributes negligibly towards climate change.
Okay. I believe that we're having a technical issue, but that we now have the Justice with us live online. Yes, this morning, I think travel arrangements and so on have made this somewhat more of a challenge. Justice, please do continue.
Good morning, and I'm very sorry, everybody, that I've put you through all this pain so far. Actually, I was traveling from one province to another, and that took some while, and I missed the session earlier. So let me just begin again, if you sort of could bear with me for a moment. Can you hear me? Am I being heard? Okay. So good morning. It's a matter of great honor and privilege to be able to share some of my thoughts on how the judges or the judiciary looks at climate change, climate justice, and the scope of future of climate litigation. At the very outset, it is underlined that the primary responsibility to address and devise ways to deal with climate change rests with the government of the day. I wanted to underline that. In a democracy, it's the political party in power to lay down the policy and for the parliament to introduce laws to deal with climate change. We, the judges or the judiciary, get to play a role when a case comes before us. No matter how proactive our approach, our jurisdiction has to be invoked by a concerned citizen or perhaps a robust civil society. So judges are not elected, as you know, by the people and thus have no political constituencies or political interests to watch for. Their oath is to uphold the Constitution, which means to uphold the fundamental or the human rights of the people. Neutrality and impartiality by design leaves the judiciary as the only institution that can effectively advance the cause of human rights, irrespective of the fact that it is against vested interests, government policy, or even upsets the political balance of power of the day. And I speak in the context of my political setting in the country, so it might not fully apply to other countries, but I speak regarding my own country. So using the creative tools of interpretation, the ever-evolving international environmental principles, and a focus on a progressive advancement of human rights, the courts have made a difference and made innovative strides in developing climate jurisprudence that promises hope. Initially, our courts evolved a rich jurisprudence on environmental justice, which revolved around penalizing the polluter or curbing pollution, largely a localized issue with an ascertainable polluter. The equation totally changed as we moved on to climate justice, and I wish to underline that. For a country like Pakistan that suffers at the hands of climate change, as there is a negligible contribution towards it by the country, this made us revisit the earlier jurisprudence, as now the polluter was no more within our jurisdiction, not even within the region. Thus, the preventive and penal approach under the environmental law shifted to an adaptation approach under climate justice. It was now more about institutions and individuals to move towards long-term structural adjustment to adapt to the new climate to avoid violations of human rights. Courts in countries like ours have less of a focus on mitigation, but more so on adaptation. Courts have been the first ones to understand this new reality. The brave new world with a changing climate required readjustment of policies and political priorities. We noticed that as the government climate washed key priority areas, disappointed the citizens knocked the doors of the courts. Therefore, the judiciary took the lead. We understood that courts could not lay down policy or legislate, but we could direct the government to implement the policy or take effective steps to protect the human rights of the people. So let me take you through two most prominent cases coming out of Pakistan and showcase what I'm trying to say. So the first one was Laghari case, comes out in the year 2018 at one of the high courts, where a farmer comes to court and prays that due to scarcity of water, the impending drought, due to the global warming, he will not be able to till his land and earn a sustainable livelihood. He prayed and beseeched the court that the government be directed to implement the national climate change policy, which was on the shelf for the last 3 years, which addressed these issues. The court could have simply directed the government to implement the policy. We could do that under the constitutional scheme that we are under, but this would not have achieved much. The court took a more innovative way forward. The court, realizing the capacity of the government, constituted instead a climate change commission. This comprised of climate experts, international environmental institutions, representatives of the government, environmental lawyers, policymakers, and of course the petitioners. The commission helped government understand the issues involved and assisted them in implementing the policy. The commission became a source of knowledge for the government because we realized the government had no understanding of some of the issues, and was also no less than an awareness campaign for the civil society. Finally, the commission successfully reported to the court that their several deliberations led to the implementation of 60% of the short-term goals of the climate change policy, which without the intervention of the court and perhaps this innovative manner that the court interfered, could not have been possible. So we moved from environmental justice to climate justice, and the court held that climate justice links human rights and development to achieve a human-centered approach, safeguarding the rights of the most vulnerable people and sharing the burden and benefits of climate change and its impacts equitably and fairly. So under climate justice, the court has to embrace multiple new dimensions and attend to them, like health security, food security, energy security, water security, human displacement, human trafficking, and disaster management, just to name a few, which were never heard of while we were doing environmental justice, because it was, if I were to say, quite a linear way of doing things, but number of dimensions were added the minute we entered the climate debate as judges. So while mitigation can still be addressed by environmental justice, adaptation can only be addressed through climate justice, where the courts help build adaptive capacity and climate resilience by engaging with multiple stakeholders. So the the whole scope of work that the justices now do is far more than we were to do while we were doing environmental justice. In another case called the DG Cement case, which came out in 2021, this was a case where an existing cement plant wanted to expand its facility, and the government refused to do that because the area was water scarce. And as you realize and know, that cement factories are water guzzlers and require a lot of water. So the government resisted, and they said, no, you can't do that, which was challenged before the court. The court held that through our pen and jurisprudential fiat, and I quote, through our pen and jurisprudential fiat, we need to decolonize our future generations from the wrath of climate change by upholding climate justice at all times. Post-climate change democracies have to be redesigned and restructured to become more climate resilient, and the fundamental rule of law has to recognize the urgent need to combat climate change. The court should be mindful that its decisions also adjudicate upon the rights of future generations of this country, promoting climate democracy and intergenerational justice. So that's what came out of that case. And the court upheld the government's decision that no, the cement plant cannot expand its facility because of water scarcity, but we linked it up with the climate change issue, saying that every policy that the government now decides or comes up with must be climate resilient. So the courts can push the governments to come up with policies to effectively deal with climate change. They can direct the climate resilience and best adaptive policies be incorporated into any future development plans. The courts can intervene to strike down any law, policy, or action, or actually stop a project which is likely to be dangerous and harmful to an already climate vulnerable and fragile country. Any such direction is for the safeguard of the fundamental rights of the people and is fully within the domain of the judiciary in Pakistan. The judiciary does not step on the toes, face, and jurisdiction of the executive or the legislature. They continue to perform their role under the Constitution, and therefore there is no issue of upsetting the balance of power. To us judges, there is no conflict between environmental protection and development, because our answer would be simple: sustainable development. We remain clear that we must restore, repair, and care for the planetary home that we take care of, that will take care of our offspring. For our children and our children's children and all those yet to come, we must love our rivers and mountains and reconnect with the long and life-giving cycles of nature. In the end, we hope that with our repeated interventions, that's of the court, that the government and policymakers will be guided and instructed to move in the right direction. Thank you very much.
Thank you.